Case is there was an employer who had difficulties with one of his employees and got in a fight with her over something, and she kind of came back to work and then stormed out and went home. Shortly after that, the employer got word that from one of his vendors that someone had gone into the vendor's computer and using the password that the company had, gone in and mucked around with the data, so to speak. So the employer went to the Lower Township Police and said, look, this is what's been happening, and the detectives who were doing it said, well, do you have any idea who might be doing this, who did it? And they suspected that it was this employee, this disgruntled employee named Shirley Reed. So the police needed to get the information in terms of who was utilizing the computer and who had accessed this particular vendor's computer. They went to Comcast and said, listen, we need information about who was going onto this computer. Can you get it for us? And Comcast said, well, we're happy to give it to you, but we really need some legal authority to do that. So the police went back to the local municipal court and had a subpoena, Dukas Taken, prepared and served it on Comcast. Now, the subpoena was kind of an unusual subpoena. It was captioned in the name of employer versus employee, number one, instead of state of New Jersey versus. It called for the production of this information from Comcast and was returnable on a date when the court was not in session. By the way, it was for a crime that the court didn't have any jurisdiction to hear, on top of everything else. Apart from that, it was a perfect subpoena. So they serve it on Comcast, and Comcast readily turns over the information, and it leads to the defendant in this case as the person who had accessed that computer. She was subsequently indicted by a Cape May County grand jury, and I think it was some type of second-degree computer-related theft. So the motion to suppress in this case really deals with the issue as to the propriety of the technique utilized by the police in obtaining this information. Now, there's a theme that runs throughout many of the cases we're going to talk about today, and it's something that just comes up in the case law just by coincidence, and that deals with expectations of privacy. You know, police have a responsibility to act reasonably when they're dealing with arrest, search, and seizure issues, but only in the sense that the duty of police to act reasonably only occurs when the target has an expectation of privacy in the area that's being searched or seized by the police. So if you stop to think about it, if you don't really have any expectation of privacy in your computer activities, then the police don't have any obligation to act reasonably under those circumstances. By the same token, if society does give you an expectation of privacy, then the police do have an obligation to act reasonably. And that's really the main issue in this particular case. Now, I don't want to get too hyper-technical. Actually, Chief Justice Radner does a really good job of explaining what happened here. But apparently, when you go on the internet, your internet service provider, Comcast, AOL, whatever it may be, assigns you a number. It's kind of, this is all done, it's all transparent to you, but you get a number for that session called an IP number. And then every time you go to a website, this IP number is there. And by accessing the IP number, you can go back to Comcast or AOL or whoever it is and find out what computer was being utilized to access that website. So the issue in this case deals with this IP number and whether or not people have an expectation of privacy in the IP number. Now, this is, of course, not a novel issue by any stretch of the imagination. It has been litigated pretty extensively on the federal level. And as far as the federal courts are concerned, you don't have an expectation of privacy in this information. Accordingly, there's no requirement that the police get a warrant or do anything else. They don't have to act reasonably under those circumstances. The issue placed before the New Jersey Supreme Court in this case is whether people in New Jersey have an expectation of privacy in this type of information. And the holding of the court under the New Jersey Constitution is yes, people in New Jersey do have an expectation of privacy in this IP number. The court fairly frequently will provide more protection to people in New Jersey than you would get under the United States Constitution. There's been a lot of litigation on this recently, all favoring defendants. The most recent case I can think of dealing with bank records. In other words, you have an expectation of privacy in your bank records. In your utility billing records, expectation of privacy. For a long time, there's been an expectation of privacy in New Jersey on your telephone toll records. This is just, in fact, you all know that you have an expectation of privacy in your garbage for that matter. But this is just one more example of the court expanding the expectation of privacy for people in our state. And this dealing with evolving technology, dealing with computers, all right? Now, if you're a police officer, what do you do when you're put in this situation where you have to go get information related to someone's computer activities from one of the providers? The suggestion by the Supreme Court is that the proper procedure for police is to get a grand jury subpoena, all right? Now, the good part of that, I guess, is that when you're utilizing a grand jury subpoena, there's no requirement that you demonstrate probable cause to believe that something is hidden in a particular location or your investigation will yield some fruits. Grand jury subpoenas are issued on the basis of relevance, and it's really kind of an attenuated relevance standard in the sense that if the information sought by the grand jury could in some way advance their investigation, then it's appropriate for the grand jury to issue a subpoena, and the grand jury subpoena can then be served upon Comcast, AOL, whoever it may be, so that you can obtain the information that you need. It is not necessary to get a search warrant under those circumstances. It requires too much proof. Obviously, the use of a municipal court subpoena under these circumstances is completely inappropriate, but that's okay. I think the court rules will probably wind up being amended as a result of this case to make sure that this type of thing does not happen in the future. But if you have one of these things, this is what you should do. Chief, I have to tell you a story out of school. One of the detectives, a detective lieutenant in your department, came to me right after this case came out and said they were investigating the same type of offense, but the worst it could have been was a petty disorderly persons offense, a harassment charge. And instead of calling Matt, the prosecutor's office, they come to me for some reason and said, what should we do? I said, well, you know, it's petty DP. You're not going to be able to get a grand jury subpoena. Do you have probable cause? Yeah, we have probable cause. Well, go get a search warrant. Well, a search warrant, that's a lot of writing. That takes a lot of time. Can't we do something? Can we get a subpoena from municipal court? No, get a search warrant. Yeah, but that means we got to call the prosecutor's office, you know, and then we got to write stuff and talk to a judge.
I already know what lieutenant it was.
So he walked out. He was not happy with the legal advice I gave him. I'm not sure what happened with the case. Guy probably murdered or something like that. But anyway, so that's the situation. So the lesson to be learned out of this, you do have an expectation of privacy in computer-related materials. Now, the Supreme Court also went on to say that this is something that may be subject to change in the future because the evolving technology may not in the future have an expectation of privacy in your IP number. They have these reverse telephone directories that can be utilized to find out who was on the particular website at a particular time. And once it becomes accessible by anybody, then you can't realistically have an expectation of privacy in that information. Now, the technology is not that far along yet, but Justice Rabner indicated in the opinion that if and when it gets to that point, you would lose your expectation of privacy, and once again, the police will not have any obligation to act reasonably under those circumstances. The next case we have is State versus MA. This case is very, very new. Doesn't have a citation on it yet. By the way, let me go look at these. I'll just make sure I don't skip anything here. Let me take a look at my overheads on this case. Let's see. Okay. Just to recapitulate what we said a moment ago, ISP records share much in common with long-distance billing records. All are integrally connected to essential activities of today's society. It's hard to overstate how important computers and the internet have become to everyday modern life. Citizens routinely access the web for all manner of daily activities. So if you have a situation where there's something new, and you're trying to make a determination as to whether there's an expectation of privacy and it's computer related, this language will give you some guidance on how the court thinks about this. This will give you the technical aspects in terms of the necessity for having an ISP address and talks about this IP number and how you physically need it and how it gets stored and how it can tell who is using a computer or at what time. All right. With a complete listing of IP addresses, one can track a person's internet usage. The government can learn the names and stores in which a person shops, political organization a person finds interesting, a person's fantasies, I'm in big trouble, her health concerns, and so on. Okay, so here's the holding of the court. For all these reasons, we find that Article 1, Paragraph 7 of the state constitution protects an individual's privacy interest in subscriber information he or she provides to an internet service provider. New Jersey courts have consistently affirmed the expansive investigatory power of grand juries. This is what I was talking about a moment ago. That power rests on the grand jury's ability to issue subpoenas to gather information, a power that must always be exercised in good faith and in accordance with established rules to avoid abuses. Under those rules, grand jury subpoenas may be issued based upon a relevancy standard. Documents bear some possible relationship, however indirect, to the grand jury investigation. Not a whole lot there that you need to get the grand jury subpoena.